My name is Kyle Winter. I'm an attorney in the area. My law firm is located in Carson City, but we practice in all counties of this state. I'm born and raised here in Nevada. I did my undergrad at Nevada Reno, so this is my home, and this is why this is important to me. And Richard said it perfectly. The idea is that you want to be prepared both during your life and be set up for what happens after you pass away. So some of the things that I'm going to be talking about today, and I know it's only a 5-minute period, but it's a very brief period about the importance of an estate plan and the documents you can have during your lifetime, as well as setting up for after you've passed away. So just a quick poll, and I promise I'm not going to call or pick on anybody, but how many people here have a financial or a healthcare power of attorney? All right, perfect. And then just to go one step further, how many of you have a last will and testament or a living trust? That's perfect. Feels like I don't even need to speak today. It seems to be a common occurrence, but the importance of that in preparing is the powers of attorney. And the worst call that I get through a story is mom or dad are in the hospital, or mom or dad need long-term care, and mom and dad don't have any documents in place or somebody to set them up to be able to make decisions for them. So the financial and the healthcare powers of attorney allow you to designate somebody during your lifetime. Tell this is the type of treatment that I want to receive if I'm unable to make my own decisions, and more importantly, this is who's going to do those decisions and follow those decisions. If you don't have those documents during your lifetime, the court is going to require a guardianship. Guardianship is not a scary term. However, it takes a lot of time and it costs a lot of money. So avoiding a guardianship is utilizing those documents such as the financial and healthcare powers of attorney. And then more importantly, after considering who's going to help me during my life is what's going to happen to my estate afterwards, okay? And avoiding what's called probate. I'm sure a lot of people have heard of the fancy word probate. It is a fancy legal term for it takes a lot of time and it costs a lot of money, okay? If you have a trust, the trust avoids probate, and you get to say this is the person who's going to step in and manage my estate and distribute it where I want to go without having to go to court, okay? Probate takes about 9 months to a year on a quick scale, okay? I say that easily. I've had probates that last 2 or 3 years just with the determination of assets that are at or the issues that are going on. Those of you that raised your hands that have a will and trust, how many of them are established here in Nevada? Okay. A lot of the things that we see, although that any estate plan you establish in any state is valid in Nevada. If it's established outside, I always recommend you get it reviewed just to make sure people in the Nevada community are comfortable with Nevada laws. So if you establish it in California and you've moved here, talk with an attorney, make sure that it's still up to date here. And more importantly, your desires may have changed. I know that, not to share too much about myself, but I've amended my own estate plan a number of times as my kids get older, as family members move out of the area, who's going to be taking care of you. But some common misconceptions about estate plans or powers of attorney. I don't need one. They're too expensive. And I want to implore you all, those that raised your hands for one, a typical probate costs about $25,000. A normal estate plan is about 1/10 that cost. So you're spending a little bit of money now to save a lot of time and money in the future. Okay. Any questions about just this? I know it's very high level, but I'll be here the rest of the day to answer any questions. But any questions?
The probate, is that a percentage of how much money you have?
It is. So they base the attorney's fees. It's a statutory rate based off of the value of the estate. So the legislature has dictated this is what we feel is appropriate that attorneys get paid to get the process through probate. And it's a shame because it's taking money away from your estate that would otherwise go to your beneficiaries.
What about a holistic will?
Yep, you can. So if you're referring to a holographic will.
I mean, a whole, yeah.
So the question about a holographic will, a holographic will is a will that's written entirely in your handwriting and signed and dated by you. It is a valid document. It does not require witnesses. Okay, so you could write down your desires on a napkin from your sandwich today. And as long as it's dated and signed by you and in your handwriting, it is a valid will. The difference with a will is a will has to go through probate. So a will is not valid until you've passed away. And the only way that a will becomes valid is if the court says we're accepting this as a valid document.
So it could still go through probate.
Still can go through probate. Yep.
Is there any way to amend a trust easily, like the Schedule A, without having to redo the entire trust?
Absolutely. So every trust is going to be a little bit differently, so I can only speak in the broad terms. As long as your trust is revocable or amendable during your lifetime, you can absolutely do that. In a vast majority of the clients that I've incurred or met over the past few years since the pandemic are those that are moving east, or people who are relocating to Nevada. And it's, here's my estate plan that's from out of state. I'd like you to review it. I want to update it and amend it because things have changed. We've sold our property that was currently in there and we've acquired new property. We want to make sure it's still protected. Okay?
So you have will versus trust, is that just, are you just saying there the difference between probate and no probate?
Correct. So if you have a will, it still sets forth your desires of this is who I want to be in charge and where I want my estate to go. The difference between a will versus a trust is that a will has to go through probate where a trust does not. If your assets are in a trust and you've designated a trustee, the person that you've designated automatically steps in once you've passed away, and they can automatically start making decisions about your property that belong in your trust. So again, it immediately sidesteps that long probate process. And I'll take one more, but then again, I'll be in the back for the rest of the day. Yes.
The question is, so you have a trust and you have a person who's going to deal with the trust, but if that person dies before you, then that would go back to probate, is that correct?
It can. It'll be dependent on the trust. Most trusts that are prepared have contingencies. So if, not to share too much about myself, but if everything goes to my children, but one of my children predeceased me, and they leave children, then it will go to their children. And then you can even dictate at what ages and when they're going to receive that based off of even a percentage that you set, always making sure that they're taken care of with their health, education, welfare, and safety. So, but again, I will be in the back. I don't want to take the rest of our time. We have a lot of great presenters here today that are going to be sharing a lot of information. So please feel free to stop by. I have some business cards and pillboxes at the front. Please help yourself. The pillboxes are small, but I've found that they work very well with flies. If you're a fly fisherman, you can keep them in your vest.